Question involving another local company with whom you are having a bit of a run-in. Well, they're a local company now, Novell.
Right.
Just announced, by the way, last week, they are now officially a Massachusetts company.
It was through their 10K, I understand.
That's right.
They announced
That's
it,
right. Yeah. So they're now local boys.
Right.
Anyway, they've got an interesting little approach to this. They say we still own a permanent, irrevocable license to SCO Unix as part of the deal with you guys. So then they turn around and they say, now we've just bought SUSE, the second largest Linux developer. We're going to sell SUSE Linux. And if any legal problem comes up, it won't apply because, hey, we have a license to distribute SCO Unix, so any copy we sell is clean. What do you make of that argument?
We make a lot of things that argument, but
You want to take the first cut? Or?
yeah, let me take the first wave. It's interesting. You actually used very good words there, very precise words. They say they have a license. They're a little talking out of both sides of their mouth here a little bit. On one hand, they say they own the copyrights. They went to the Copyright Office and said, we own the copyrights. But on the other hand, in the public marketplace, they're saying we own a license. Okay? They licensed back the technology. They sold us the technology and then they took a license back. It's bizarre to say you're owning the copyrights at the same time you took a license back from the people that own the property. That's the first interesting point. When you dive down in and you do a thorough reading on all the contracts there, what you see on the license back portion says that they receive a license back to use the technology for A, internal purposes, or B, externally, so long as it does not compete with the core products of SCO. And it's a substantial part of the value proposition of the packaged product. So that becomes an interesting question. Our product is Unix. Does Linux compete with Unix? Okay? That is going to be a question that the courts are going to be settling on that front. Right now, we're just very singularly on the point of copyright ownership issues, and that's why we filed the lawsuit.
I guess the one thing I would add to that is, many of you are in law school or have completed law school now. If you think back to your contracts classes, do you interpret a legal contract in terms of the whole document, that the basis of the contract is the whole document, or can you interpret it based on selectively just a few lines that are of most benefit and desire to you? No, it's the whole contract that matters. And so what unfortunately appears Novell is doing is selecting out and cherry-picking the best parts of the asset purchase agreement with SCO and trying to spin that out there and create confusion. And we'll have our day now in court to settle that issue with them, and we're very confident of our position because in two areas. One, in terms of the copyrights, and second, in terms of this perpetual and irrevocable license. The only thing I'll add to that is there was a perpetual and irrevocable license that Novell would obtain based on their license back if SCO had been purchased within 2 years of when Novell sold to old SCO the Unix business. Well, old SCO was not purchased, or there was no change of control that occurred within that 2-year period, so that unlimited perpetual license back did not occur. Also, in that same contract, there is language that says if Novell ended up competing with a business that is substantially the same as what they had sold us, so they sold us this Unix business and then turn around now with their SUSE Linux business are competing with SCO, there is a limitation of their license where it becomes substantially less and incapable of supporting their desired license to a broad audience of rights they really don't have.
Okay. Let's see. We haven't got anything on this side of the room. Let's go over here.
Doing on time. Okay.
One quick question. We've talked primarily about companies owned and operated within the U.S. I just wanted to get a sense of the international implications for your arguments. Specifically, China, for instance, an emerging market, particularly in the desktop realm. And where do you guys fall from an intellectual standpoint, and who do you appeal to make sure that your intellectual property rights are protected across the world?
Want me to take If you're familiar with copyright law, there is a lot of international conventions and so on that have established bilateral agreements between different countries in terms of respecting and enforcing each other's copyright laws. So most of the major countries around the world, there is effective reciprocal action. If you have a U.S. copyright and have registered it in the U.S., that you have a very high level of rights in many other countries around the world. There are a few exceptions to that, a few countries that do not fully recognize copyright protection or don't see the value of copyright protection or other intellectual property rights protection, which, as a world body will continue to be, worked on and hopefully corrected. But for the majority of the major countries around the world, we have a very strong basis and mechanism for being able to enforce our copyrights and other intellectual property and contracts in just about any place around the world.
Except China.
Except China.
Yes. Hello. I just have a couple of quick questions in regards to the concept of copyright to specifications and as a programmer, header files or interfaces as opposed to the actual implementation. Right. For example, when you're sharing software, particularly for collaboration, you will publish an interface, but you'll keep your implementation private. And if other person chooses to implement that, they can, and then they stand up on their merits. Right. Does copyright apply to both? And if so, if the interface is made part of a public specification, can that then later be claimed as part of the copyright for your own implementation, thus making the implementation of that specification by a competitor invalid because it's programming to the same copyrighted interface?
It's a great question, and as we
if we have a couple hours, we can.
Well, but the real simple answer is, if you go through and look at there was a big court case back in '94 that was settled between AT&T and BSDI around the very issue of, the different versions of Unix and how much was over here and how much was over there. And one of the things that came out of this, as Chris said earlier, were 90-some-odd files that were protected for SCO or for AT&T at the time, and a number of these were tied into these header files or the interfaces. Okay, so it reinforced the copyright protection. These transferred over. We do have those copyright protections, and that, in fact, so the way it reads is, in a lot of these files in BSD, if they put the files in, they could use them, but they just had to include the header information. They had to give attribution notice to us. If you look at the DMCA, it actually gets to this very issue of if you file off copyright header information, that's a violation under the DMCA. There's a company out there that we used to be associated with called Lineo that was sued by a Linux company called Monte Vista over this very issue. You took off header file information. Lineo ended up paying in that case. So this is exactly the same case that we're on, and we feel that we have very strong rights.